Today we're going to talk about the duty of good faith. And while the duty of good faith is sometimes presented as a separate duty, it really is an overlay or a way which we interpret all contracts, because the duty of good faith is implied in all contracts, and it's really just a question of how that duty affects a certain situation. So we will first try to understand what does it mean to have a duty of good faith, and then we'll see an example where it applies in a particular situation. But the thing about good faith and a concept like this is it is inherently fuzzy. It's kind of an equitable concept. It has to do with reasonableness and facts and circumstances. And so what you have to do is you have to look at what a reasonable person in a situation would do. You might even say have different sort of standards. What would a good person in a situation like this do? What is the right thing to do? We have the sort of moral overtones that kind of come through a little bit. And we have questions about to what extent courts will hold parties to sort of a higher standard. But in any event, it's going to be very, very fact-specific, because it really has to do with how parties what is reasonable conduct in a given situation. So it's one of these things where I can tell you the rule, but I can't give you every permutation where the rule might show itself. That said, here's the rule. Right? The rule is located in two places, the restatement and the UCC, and the restatement has it in section 205, and says, every contract imposes upon each party a duty of good faith and fair dealing in its performance and enforcement. There's something missing from this definition. Contract formation. It doesn't say formation. It says contract performance, contract enforcement. It doesn't say contract formation. Now that's sort of interesting. And in fact, in the Judge Posner opinion we'll spend some time with today, maybe we'll get a little closer to understanding why there might be a duty of good faith once there's a contract, but something less than that before there's a contract. But note, the definition here is pertaining to performance and enforcement, so that's why we're learning it now in our chapter about interpretation, performance, and breach, and then remedies, right? So it falls into this part of the class. We didn't go over this definition during formation, and in fact, as we'll see, formation works a little bit differently. And what I'll make an allusion to is I'm going to start now talking about contract parties as being in a relationship. We'll define that relationship a little bit, but it's a relationship that didn't exist before the contract. And now that parties have a relationship with each other, they owe duties to each other in a way that unrelated parties would not have. And this might come from expectations parties might have of contract counterparties, what have you. So, Restatement section 205, this is our rule, and absolutely it's missing what good faith is, and we're going to spend a little while today looking at that. By the way, there's like dozens of law review articles, so there are hundreds of pages written on the topic. I'm not going to go over all of that today, obviously. But yeah, that's not in here, but also formation. And maybe that gives us a clue as to what good faith is, because it applies to parties that are in a relationship, but not before the relationship. If we have a contract for a sale of goods, goods being things that are movable and identifiable at the time of sale, the UCC applies. And indeed, UCC also provides an obligation of good faith here in section 1304. Every contract or duty within the Uniform Commercial Code imposes an obligation of good faith in its performance and enforcement. Doesn't say formation. Interesting. Very similar definition. So it looks like whether we are in the world of the restatement and the common law, or whether we are in the world of goods and the UCC, we have essentially the same standard. Now, to your question, what is it? Without being exhaustive, I can tell you that there are at least 6 ways, and many, many more, to think about, even this is just a framework, to think about what this concept might mean. It's sometimes described as an implied covenant, which is why I put that first. We're learning it in the section on implied terms. A covenant is another word for a promise. And so it's an implied promise. A promise then to what? A promise to act in good faith. And so in all contracts, there is an implied promise to act in good faith. Okay, that's true, but that's not very helpful, is it? Right? That's a circular sort of definition. It doesn't answer the question what good faith is. What it is something that's in contracts. Well, we kind of knew that from the rule, but anyway, that's one way it is described in the literature. Another way it's described from a practitioner standpoint as an argument of last resort. Why? Well, because just like contra preferentum, construction against the drafter, and other sort of equitable doctrines, we always want to find a legal remedy first. We always want to honor the letter of the document, and if we somehow can't determine what that is, maybe then we can look at the spirit. This is a very much equitable kind of concept here. And just like we look for consideration before we look for promissory estoppel, just like we try to resolve the disambiguity through the 13 semantic canons before we turn to a policy canon, we also will try to resolve a contract dispute based on what is written on it, as opposed to what might be inferred from it. So a way to think about it is that this is an argument of last resort that we would only use if other arguments fail. It's described sometimes as honesty in fact. And that's one that I've read in the literature, and you see in some of the cases, I am not sure what the heck that means. And I'm open to some ideas, but that's at least something that is discussed. That may or may not be something helpful, but I see it in some cases. They describe good faith as honesty in fact. I don't know how that's different than honesty in law or just honesty. And as we'll see, courts don't require candor or necessarily divulging information, and it's not clear to what extent parties in a contract need to reveal private information. But I'm at least bringing to your attention that some cases call it honesty in fact. Maybe a better term, which is a little easier, is commercially reasonable fair dealing. I like this term because it actually gives us a little bit of a hook to hang our hat on in the following sense. We can actually determine what is commercially reasonable by asking people in the trade. We could determine trade usage effectively. This is very similar to determining the standards of conduct. So there might be ways that terms are used in a trade, and there might be ways parties conduct themselves in a given trade. You ever heard the expression like honor among thieves? And so this is an idea that even in the industry of thievery, there still might be some standards of conduct. There might be some commercially reasonable fair thieving or something like that. So we could determine that by extrinsic evidence, by looking at participants in the trade, various experts. So I kind of like that definition because it gives us something, I think, a little more concrete. It's sometimes described as reasonable efforts. Reasonable efforts. Well, the problem with reasonable efforts is, again, anytime you see the word reasonable, you have to think facts and circumstances. Facts and circumstances. What are the facts and circumstances that would make conduct reasonable in this case or not in this case? What does reasonable mean? How much effort is a reasonable effort? I'm not sure that that definition gets us any closer to a concrete understanding, but we might also look at reasonableness as something we can determine through concepts like trade usage or what have you, maybe through philosophy or some other type of conjecture. I do find that definition a bit slippery, but the concept of reasonableness is slippery, right? What does it mean to be reasonable? At least it does give us a sense that it's an objective kind of standard, right? What would an ordinary person in like circumstances do and that sort of thing. And then finally, good faith might simply be the absence of bad faith, right? I mean, there's good and there's bad. There's black and there's white. There's night and there's day. Well, except there's actually kind of a lot of gray, isn't there? There's also dusk and gray. So I'm not sure that we can divide the entire universe into a yin-yang of good faith and bad faith. And I'm not sure that good faith is the absence of bad faith, but some courts treat it that way. Some courts will use the existence of bad faith as evidence of the lack of good faith and see them as effectively describing the entire universe. Everything is either good faith or bad faith, and so the presence of bad faith shows the absence of good faith, And I think that's what Posner does. And so, while I can't get my brain to think that way necessarily, I guess I just see, at least 50 shades of gray in between the two. Judge Posner seemed to think of it that way. And so I think we should also try to see maybe that definition is helpful. So again, this is an unclear, moving, complex area of the law. If you want to fixate on sort of the most concrete definition, I think commercially reasonable fair dealing at least gives you a sense that we could achieve some knowledge of that by asking people who were in that trade what they generally did and what people would generally expect. But if you want to give the courts more discretion to take sort of an equitable approach about what's fair and reasonable in a particular circumstance, calling it reasonable efforts gives the court a little bit more freedom. Bad faith might be more descriptive than good faith. The UCC seems to accord with Posner. And so the UCC maybe gets us a little closer to understanding this. It says that in UCC section 1201, 20, 1201 is a definition section, and 20 is the 20th definition in that section. It says that good faith, except as otherwise provided in Article 5, means honesty in fact and the observance of reasonable commercial standards of fair dealing. So, honesty in fact, again, please, during our Q&A, during our conversation, let me know what that means. I'm not entirely sure what honesty in fact is, and I've tried. But that said, the UCC does point to it, and then this commercially reasonable standards of fair dealing, I think that's something concrete that we can actually, arrive at through a process of taking testimony, taking depositions of people in the usage of trade. And it's not, surprising necessarily that the UCC provides a little clarity. It is a statute. It's designed to be clearer and less flexible than the common law. So let me go back then to this concept of good faith is not bad faith, because this is a nice bridge to our Posner discussion. Since the good faith definition seems to resist definition, although I'll posit that commercially reasonable fair dealing might be something we can define, maybe bad faith is a little easier to define. And some people have tried to do this. And so I pulled this from an article, and I apologize. I usually provide my sources. I don't have that on the next slide here, but I didn't write this. So just in fairness, a very good article spoke about how we could understand good faith as a more concrete example of not bad faith. So let me tell you a few examples of things that are generally understood as what it requires to act in good faith, and you can decide which is more clear, which is more concrete, which is more understandable, the good faith or the absence of bad faith. So on the one hand, we can have a requirement that a seller fully disclose material facts. Fully disclose material facts. So we understand what facts are. We might have a little bit of wiggle room around what's material. But we have some tools to arrive at materiality. Maybe materiality is something that would change a person's decision. Or we could make materiality a certain percentage of the transaction cost. On the other hand, we could say that a seller cannot conceal a defect in what they're selling. Cannot conceal a defect. I think that's a little more clear in that particular example. I mean, material facts gives a little fuzziness, but can't conceal a defect. Well, that sounds like someone who's painting over the crack in the basement. We kind of maybe can understand that a bit better. So maybe, in that case, bad faith is a little clearer than good faith, at least a little. But also it's less flexible. On the good faith category, good faith would be substantially performing without knowingly deviating from specifications. Okay, so you're producing widgets and you're doing your best to make widgets that are the right size and shape. Okay, well, there's a little fuzziness there. Substantially perform. What is substantial performance as opposed to total performance or insubstantial performance? We're actually going to learn a little bit about that doctrine after spring break. But it's a little fuzzy to say substantially perform. What rises to the level of substantial? Now, we could have a test for that. We could say 90% is substantial, 95% is substantial, benefit of the bargain is substantial. There could be a test for that, but it's a little fuzzy. On the other hand, we might use bad faith, where a builder and the other thing is knowingly deviate, right? So we probably can arrive at knowingly, but maybe we want to make that broader. Maybe knowingly should be knows or should have known in order to put the right incentives on discovering that sort of stuff. Bad faith, the builder willfully fails to perform, though otherwise substantially. So a willful failure to make the widgets the right size, knowing that you're producing widgets that are too small. That's clearly bad faith. Again, it's more concrete, probably easier to understand, but I want you to see that that's narrower. That applies to fewer circumstances. So we have a trade-off between breadth and ability to be flexible and clarity, once again, with the use of bad faith as an excluder. How about a requirement to act fairly? Is that clear? What does it mean to act fairly? Okay, I see no hands, right? Because, again, acting fairly will depend on the circumstances, won't it? I mean, acting fairly to your little brother while playing a pickup game of basketball might be different than acting fairly as the CEO of Microsoft who's trying to purchase a unit from Google. Right? I mean, like, very hard to generalize what it means to act fairly across all contexts. All right, so maybe more clear, a contractor cannot openly abuse their bargaining power to coerce an increase in contract price. That's pretty clear. Yeah? Having someone over a barrel, or for that matter, I'm the only game in town, and so I'm going to charge double, even though that has no relationship to my cost structure. Right? Or we're already in a contract, we're 6 months into the agreement, maybe we haven't defined how much it will cost. I've already built the floor, and now it's time to build the roof. We haven't agreed on that price. We're already in a contract, but now getting someone to take over my job at this point is going to be really hard and expensive. So I'm going to extract all of that wealth from you. So this is, again, it's more clear, right? Can't you see that it's clearer to say that a contractor can't openly abuse bargaining power to increase a contract price, as opposed to say a contractor has to act fairly? But it's also narrower, and it may or may not get us where we want to go. I mean, other concepts in good faith that are often advanced, to act cooperatively, to act reasonably, to accept reasonable assurances. Reasonable. What's reasonable? The only answer to that question in the abstract is, it depends. What's reasonable depends on the parties, on the circumstances, on the subject matter of the contract. The whole reason we use the term reasonable is to give us wiggle room, to make a concept flexible, so judges, in their discretion. And if we didn't have concepts this, by the way, you all should be seriously afraid of your jobs because we could be replaced by computers. This is where humans, and you might be, well, that's hard, that's abstract, that's difficult. You should be thankful for that, because the rest of the stuff could be coded into a couple lines on an app. This is the stuff that's hard. This is what you're going to be paid to do in the future, right? Not to be a functionary. But it is hard. It is hard, and it's flexible on purpose, though, because we think, at least, that gets us to a closer approximation of what's really right and what we really want contracts to do. On the other hand, we can provide a litany of specific examples of bad faith. Hiring a broker and then preventing them from finishing the deal. We'll see that in a real estate contract. Or arbitrarily and capriciously exercising power to terminate a contract. That's clear, but it's narrow. And it is possible that where we have a big space of abstract concepts of good faith, that we have to do some real work, maybe we could fill all that space with a lot of little tiny examples of bad faith. Right? I mean, there could be a computer program that just says, did any of these 7,000 things happen? Those are all bad faith, right? Or we could have a human that looks at a circumstance and says, under all the facts and circumstances, did this person act with good faith? And so for that reason, I think we need to be careful about using the concept of bad faith and having a set of, I get the desire. I get why law students, lawyers, judges, practitioners, people who contract, you want a list. You want a bullet point list, a checklist that you can look at and determine, did any of these even if it's 700 things, we can program a computer to figure that out. Problem is, what about 701, right? What about the next, how do we add or change that list? And for that matter, we're not there yet technologically, sociologically. Good faith is the opposite of that. Very flexible, very abstract, but it gives you the ability to use your reason, to use your logic, your sense of fairness, your advocacy skills to convince a court or a counterparty what is fair, what is reasonable. Harder? Yes. More abstract? Yes. But does it arrive at the right result in more cases? I'll leave that for you to decide. Brief note on contract formation. Obviously not the subject of the main of this class, but as we're thinking this through, I did mention that the definition does not seem to apply to formation. However, there are some actions that a person, it's not that, I don't want you to leave with the impression that you can do whatever you want during contract formation, right? And that parties can do whatever they want without any type of sort of liability or risk of being in violation of some principles of good faith that might apply. I think that the requirements during formation are far lower, but there are some things that parties during a formative process are expected to do. If you negotiate with somebody else, not because you want what they have to offer, but you're trying to prevent them from participating in the market, that's a real problem, right? And that has some real consequences for competition. So, let's say that you're one of several investors and a company comes along looking for money. You don't want to invest in this company because you have another company in your portfolio doing the same line of business, maybe creating artificial intelligence to put lawyers out of business, right? You have Legal Sifter in your portfolio, and the next AI company comes along. You don't want to invest in this company. You want this company to fail. And you use the contract negotiation process as a way to tie them up, take their resources, and then give them bubkiss. Right? This is a real issue that could result in a finding of bad faith during a formation process. That's pretty egregious, though. You'll also see in some contexts an agreement to agree. Sometimes you'll see a term sheet that says non-binding. And one thing that I try to communicate to my students in my venture capital law class, where we analyze term sheets, and my American business planning class, which I teach to international students, where we analyze term sheets for employment, and what I talk to my corporation students about, is that just because there's an agreement to agree doesn't mean the parties have no relationship. There is a duty of good faith to try to come to an agreement, right? Not to use the negotiation process, not to walk away for no reason, but even though a contract might say, even though a term sheet, even though preliminary negotiations, which a term sheet is part of preliminary negotiations, might say non-binding, there still is an implied duty to act in good faith to try to reach an agreement. And so that also comes up in some cases. And, you get kind of recklessness, concepts, entering a deal without intent to perform or recklessly disregarding prospective inability to perform. Sort of reckless disregard where you're almost level of intentionality, but obvious abuses of the formation process are not going to be supported in law. So back to then the subject at hand. To be a little more clear, we're in an equitable space, right? We are now kind of implying terms in equity, if you want to think of it that way, and that's how these moralistic overtones kind of permeate a little bit, and we're thinking about, did the parties do the right thing? And as a result, I have a religious figure and a quote that I'll bring up in a minute about that. Other comment, just in terms of framing, is that I'm not talking necessarily about dishonesty. And as we saw, and I hope you've seen in other examples, it's not just about lying. Even if you're not telling a bold-faced lie, you still might be acting in bad faith or not acting with good faith. I mean, it could be not good faith to omit something or to produce something that you willfully knew was not going to meet standards or characteristics. Yeah. Good faith is a singular concept that has myriad implications and requires a serious, in-depth analysis of the facts and circumstances. The temptation to define a list of everything that's bad, I can certainly understand. It would make our lives easier. In fact, we could then automate the process of determining if a party behaved without good faith. But it's not necessarily possible to define everything bad a person might ever do in advance, because, quite frankly, evil and bad action and bad faith, I think, has infinite forms. And the law needs to be sufficiently flexible to police for those things. Otherwise, we could have certain distortions as, just falling right outside of the prescribed conduct. Just because you're in a contractual relationship, you don't have to show all of your cards there either. But there is some duty that emerges from being in a relationship, and I think we can summarize it by saying that when you are in a contractual relationship, you cannot take deliberate advantage of an oversight by your contract partner. And maybe that's closer to defining something which is inherently indefinite.